Thanks for being here, and thank you to Martha and Suyi and Natalie and everyone here at CNS. This is about 15 minutes, very high-level overview without a lot of specifics, because those will come, I think, over the next day and a half on where the field of law and neuroscience has come over the last 10 years. It's a very personal talk for me, because this is 10 years ago. It's great to be back. A lot of you in the room were here 10 years ago, and some of those who can't be with us today, at least for our cohort, this really launched our careers, and has had a very meaningful impact on the trajectory of what I've done. So here's what I want to do, really just make 3 points. The first is that, and this is, I think, just a really important point. It's already come up a little bit. A lot has happened in the last 10 years, and I'll just say a few words about that. There's a lot more neuroscience in law than there was 10 years ago. For better, for worse, who knows, but there's just a lot more of it. Second thing, I've spoken with a lot of you about this, law and neuroscience is not just about criminal law and neuroscience, nor is it just about fMRI and neuroscience. It's much more than brain scans, and I'll say just a few words about that. And then observation 3 is that looking ahead, I think it's a little unclear where all of this will go, and we can discuss what we think is going to happen. All right, so point number 1. There's a lot more neuroscience in law than there was 10 years ago. Just around the room, it's evident. I was just here, sitting here, looking around. Just about everyone in this room has written a book in the last 10 years, or like Debbie hosted a conference, like Jane also hosted a conference, or like you guys started a new book series. There's a new series new since 2009, out of Duke with Walter Snit Armstrong. There's a new case book. There's Kevin's book. I mean, there's just so much, over thousands of pieces. That's not an exaggeration. Thousands of pieces of new scholarship. As Debbie's database, as Nita's database, as others have found, there are thousands of new cases, and that undercounts the number of cases because we don't have good data at the trial level, right? It's on the appellate level. So you've got thousands of new cases, thousands of new scholarly publications, thousands of judges, and even more attorneys who've been exposed in one way or another to neuroscience. This is something that just simply didn't exist 10 years ago. Now, it's an open question, and there's not time now for, I think, to go into it, but I just want to flag about whether or not and which of these developments are good things, and what normative lens we want to use to assess whether these are good things. And this is one of the big tensions in any and law field. What are your normative predispositions about the way that the justice system or the way the law should work? And for most, neuroscience is a good thing if it helps advance those pre-existing goals. I want the world to look like this, and if neuroscience or anything else helps me make the world look like that, for my client or more system-wide, then I like it. And if it doesn't, then I don't like it. To some extent, perhaps neuroscience will change one's moral bearings as well, but I think from a practical perspective, it's the lens that most people put on it. And again, it's unclear kind of then what we do to evaluate. I'll just pull one example, ripped from the headlines, ripped from the very recent headlines. The sentencing was last month. The underlying action was 2 years ago. This is a picture, August 12th, 2017, when James Alex Fields, you can see the car there, he was driving the car. These were the race-related protests and then riots in Charlottesville, Virginia. He drove his car into this crowd. This is the defendant on the right, the convicted offender now, and the victim, Heather Hare, on the left. So the crime was in 2017. There was no question he was going to get guilty on any number of charges, just the way the plea deal worked out, and it's all about sentencing. And what I want to flag for you is that the defense at sentencing, at federal level, led off. Now, it wasn't like buried in their brief, it wasn't a footnote. Here's what they led off with. They said contemporary neuroscience proves that the constitutionality, because he was 20 years old, so they said it proves that the status of juveniles must extend to 21. They went on to say, again, page 2, right front and center, one reason researchers have learned so much is the advent of functional magnetic resonance imaging. So maybe, arguably, one of the most important cases, just highlighted cases the last couple of years, what shows up in the brief, front and center? Not just neuroscience, but fMRI. It's right there. That simply didn't exist 2 years ago. Now, the prosecution, I thought, and I know that I've met this U.S. attorney, I thought came back quite well in their response in talking about both sort of constitutionally, it never examined, and look, the actions just don't seem to fit into this neuroscience paradigm. So again, I don't want to dwell on whether or not it was an appropriate or inappropriate use. I have my views. I simply use this as an illustration to make the point that what had been contemplation, what if we started making these arguments, is really application now. We've had 2 brain-based lie detection cases, actual cases, where a federal court in Tennessee and then a state court in Maryland had to decide, should we admit this fMRI-based lie detection evidence? It wasn't what if, it wasn't contemplation, it was actual application. This raises a lot of questions, which, no time to talk about, but the point is that these versions of my brain made me do it, or I couldn't control myself, et cetera, are showing up. And they're showing up pre-trial, guilt phase, sentencing, and post-trial. I'll just add one more flavor on this before I get into the rest, that lawyers will get creative. So here's the setup. Just from the last couple months, I always test myself. Can I find something just in the last 8 weeks? I always can. Attorneys for a defendant named Grant Amato, he's accused of killing his parents and brother, requested an MRI. You'd think you want the MRI to show he's got a bad brain, right? Watch what the lawyer says. The setup is, he's just been asked by a reporter, why do you want the MRI? Here's what the attorney says.
Also in court today, a judge approved a motion to allow Amato to get an MRI or a brain scan before the trial begins.
The opposite. We're trying to show that he's normal, therefore he would never have committed this crime.
Did you get that logic? I want to get a brain scan to show that my defendant is perfectly normal, and because we think only someone who's really abnormal or crazy would kill his grandparents, therefore it helps my case, right? So again, I have all kinds of concerns about this, and I see Stephen probably, you're going to roll over in your chair there. But the point is simply that this did not exist 10 years ago in the way and the magnitude that it does now. And it raises some real concerns, actually, as well, which we're discussing. All right, so that's point number 1. I think it's uncontroversial, just that it's showing up more. What is controversial is, again, whether or not and in what context it should be used. Second point is that law and neuroscience is really expanding in a lot of ways that have nothing to do with criminal justice and in many cases have nothing to do with fMRI. And let me just give you the laundry list, which is incomplete but I think useful. So FDA, FTC law, I saw Anna Wexler walk in at some point. How do we regulate new neurotechnology, including direct-to-consumer brainware? Regulation of new research and clinical trials. Implantable devices were mentioned, raising ethical questions such as, once the trial, the 5-year NIH-funded trial is over, what do you do with the thing that's now implanted in your brain, right? Very different than the drug trial. Immigration law, just got emails this week about this, the integration potentially of neuroscience into questions of memory and trauma. Elder law, will, trust, and estates. This is a really big deal in part because it's one of the places where neuroimaging and other and other biomarkers are actually having a clinical role. And therefore might have some legal implications as well. There's just a lot of crossover with related fields, genetics, AI, broadly learned biology. It's showing up in environmental law, food law, effects of toxins on the brain, health law, brain screening. There's a lot of animal law research, entire conferences devoted to the extent to which certain animals, or maybe a whole bunch of them, based on their cognitive function, should have rights or should at least not be killed daily in labs. Privacy law, all that data sharing you've heard about already today are raising deep questions about how do you protect data security and data privacy. Evidence, Jane will talk to me a little about this, but just, how do we look at our evidence law foundations, insurance law, coverage for mental physical divide, copyright law, Mark Bartholomew, a neat scholar writing about trademark and neuroscience. There's a lot of neuroscience pain work factoring in disability and social security law. Of course, on the practicing bar, where people make money on neuroscience and law is in brain injury cases. What used to be a slip and fall case is now a traumatic brain injury case. Questions of malpractice and max turds. We've heard a little bit, you're going to think hear more in just a little bit about educational neuroscience, but education law, special education plans. Constitutional law is showing up in very interesting ways. There are over 10 states that have passed laws related to the regulation of abortion, and front and center there is actually neuroscience related to fetal pain. Again, controversial, but showing up, capacity to contract, and so on. And I think one of the open questions for the field is, how do we define this? Is there a broad enough sweep? Is there a through line? Is there a set of questions that can kind of bring these things together, or are they all distinct? open questions. All right, so a lot's happening in different areas. That's point number 2. And then point number 3 is just there are a lot of challenges and a lot of possibilities. Let me start in terms of the good news and the bad news with the bad news. So I think part of the challenge, not really the bad news, but the reality is that the brain is extremely complex. You've already heard this, and therefore trying to understand the way that circuits work together to inform clinical, let's just say clinical practice, let alone legal doctrine or legal practice, can be haltingly slow, which leads to this tension of do we know enough in certain areas to do one thing or another. That's a challenge. There are some specific challenges, and that's a general challenge of law and science. There are some specific challenges. One that I'm very attuned, I think a lot about because I get these emails every week from students, is that there are virtually no, there's one at University of Wisconsin-Madison, a small program, but there are very few training opportunities for younger cohorts. So the postdoc that I was very fortunate to do in law and neuroscience with the MacArthur Foundation Law and Neuroscience Project was grant funded. It no longer exists. The neuroscience bootcamp this year, it's just tough to keep it going because as a funding strategy, it's tough. You're not doing basic science. You're not curing Alzheimer's, so you don't get that funding. You're not exactly doing legal practice, right? You're trying to tie these things together. Now we're getting, work like, Debbie, your center and others work, which is great, is trying to bridge that divide, but it's tough. So that's a structural challenge. And when you don't have training for students and you don't have training for attorneys, you get some of the video clips like we've seen before. So there are those substantive and a whole host of other challenges about applying neuroscience and law. Again, we'll talk a lot, I think, in some of the other sessions. But I do think there's some good news. And I guess I'll end on that note and we'll go to discussion. So at the broadest level, to me, the good news, this is what motivates our work in our lab, is that it's kind of trite maybe to say, but I think useful to remind ourselves that every story, both our own and those that the law encounters, is a brain story. That is, it's also a really poorly understood brain story. The quote that I like comes from a neuroscientist who says that if understanding the brain is like running a marathon, we've come 3 inches. Which I think is about right, but at least we're running the right race. At least we're looking at the right organ, connect it with the rest of the body, and in some of those contexts, it may have some purchase, maybe, and that's a challenge, but I think it's worthwhile. There are, I think, groups trying to do it. I'll just say, the one group that I've worked with a lot and now what we're trying to do at the MGH Center for Law, Brain, and Behavior, the basic idea is better decisions aligned with science, not just limited to neuroscience, might lead to better outcomes aligned with justice. But that aligned with science part is a really tricky thing because the science is not science for just public defenders. It's not science just for prosecutors. It's not science just for plaintiffs' attorneys. It's not science just for insurance executives. So I think this is, again, a fundamental tension. If you're true to the science, it's very challenging sometimes to know how to translate that into an adversarial setting if you're going to really stick with your guns. And stick with where the science says things are. I'll leave with this picture. Those of you at the first boot camp may remember it, maybe not. I pulled it out of the archives. This is, I don't know, Martha, if you still have this, but we gave this was the present we gave to you, signed. And I thought it was a fitting reminder that there is a lot to contemplate here. I mean, we could talk, well, many of you have written, Pete's written an entire book on the moral conflict of law and neuroscience. So my 13 minutes here can't do any of that justice, but it is to say this is a really active area of inquiry. It's an active area of practice. It is no longer the case that this is just what if. This is really a question of what now, and many of you in the room are leading this. So with that, I think I'll stop, and I think I have a few minutes for questions.
Great.